This is a hot mess. And I'm going to tell you now, you have so much drama in the wake that you've left. I'm going to keep you so close to me that you're going to think we're in a darn relationship. That's how close I am. I'm going to do everything in my power to protect every single person of Harris County. And I don't care if I hurt your feelings or you get a little upset because you have to come to court a lot. You're going to be coming to me, testing so much, and you're going to be hanging out with me so much that you're going to think it's a career. Do you understand, Mr. White? As it stands now, I am going to revoke your bonds and I'm going to set them, I don't know, probably commensurate to what your felony bonds are now, because it's evident that you continue to do whatever you want without consideration to any kind of court orders. It's just to every single court. There's nothing that you need to say. What you say to me now goes in one ear and goes out the other. Actions speak louder than words, Mr. White. And you just got out of prison, and now you have another. You literally just got out of prison for felon in possession, and now you have an evading arrest, felon in possession, evading arrest, another felony evading arrest, and now you've picked up an assault of a family member. It's over.
Today's hearing took a dramatic turn as Mr. White faced a serious assault charge involving a violent altercation with his own stepfather. The accusation? After being asked to turn off his mother's car, Mr. White allegedly kicked in a door and punched his stepfather in the head, leaving visible injuries behind. But that's only the beginning. Judge Fleischer, visibly frustrated, revealed Mr. White's extensive rap sheet. 8 to 10 open cases, including felon in possession and evading arrest, dating all the way back to 2018. Even more shocking, Mr. White had just been released from prison and already picked up new felony charges. Defense attorney Josh Rice fought back, claiming this was a family dispute gone wrong, and that the stepfather even wanted to drop the charges. But Judge Fleischer wasn't convinced. The tension in the courtroom reached a breaking point. But what happens next? Now let's head back inside the courtroom.
What else did you have to say?
Judge, so I do see some of the offenses do predate his TDC trip. The ones that predate, it looks like he has a Berg cab that's active in 2018 out of Richmond, so Fort Bend.
So that's still open now?
I don't see a disposition at all in that case. UUMV and burglary of a vehicle out of Rosenberg, so I believe that's still Fort Bend.
But now that makes 8 cases open.
And those are before his TDC trip. And I see on the burglary of a vehicle, not the other cases, that there is a warrant out. He absconded. So after he went to, and he has a warrant. So
that's an open warrant now?
Yeah. And
Josh, did you know about that?
And where is that out of?
So this is the burglary of the vehicle, Fort Bend County Court of Law 2.
We were just, I don't want you to say
anything at this moment.
We just appeared in Fort Bend and they didn't say anything about that, but I will figure out what that's about.
Maybe they resolved, this is what I read as of today. Maybe they just haven't updated this, the criminal history yet. He has an evading with a prior out of, let's see. It shows pending, but it also shows a disposition date. So I'm just going to disregard that charge. It doesn't.
Is that Fort Bend as well?
Fort Bend, Richmond. Yeah. So Fort Bend, it's 240th District Court. With regards to his open cases, he has tampering, fabricating physical evidence with intent to impair, third-degree felony, Rosenberg, possession of a controlled substance, interference with public duties, and then the Houston cases. Let's see, burglary of a building, Fort Bend again.
What we're going to do now.
That also shows absconded, but he may have posted those two.
I'm going to let you go back. I'm going to let you talk to your lawyer. Before you start saying stuff to me here, I want you to speak to your lawyer so you guys can decide on what you want to say, because I don't want you to say anything that hurts your cases as it is. What I'm deciding now is how and what to make your bonds at. That's what I'm deciding now. So before I set a monetary amount, I want you to be able to talk to your lawyer, you guys powwow, and then I'll bring you out and then we can talk.
Yes, sir.
Okay?
He has,
I'm sorry, go ahead.
he has 2 cases out of El Campo and I think another 2 cases out of Victoria.
So he has another 2 cases open and elsewhere.
So the El Campo cases that I see are evading with the prior, tampering, fabrication, physical evidence with intent to impair. And then the ones out of Victoria, Mandel controlled substance PG1B, less than a gram. So 3rd-degree felony there, and then just possession of marijuana. And that's it. That's all I can find.
Okay, so, Josh, let's go back. I'll have you talk to Mr. White. I'm telling you now that for me, it's going to be in the quintuple digits. Okay? It's just a matter of how much. I mean, being that, I don't know, what did I hear? 8 cases, 10 cases, give or take, something like that. We don't even know how many I don't even know if you know how many open cases you have. All I know is that where you go, trouble follows. So hold on. I'll let you talk to your lawyer. You decide what you want to tell me, and then we can bring you out whenever you guys are ready. Should he call the 2689 number? Okay, so just go back and then Josh, I'll give you the number now, and then just call back there, and then when you're done, just pop back in and we'll talk, okay?
Yes, sir.
How you doing today, Your Honor?
Not happy with you?
Yes, sir, I understand.
We'll get to it. Everyone keep it down, please. Mr. White, you are now stand charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. So you know you have a lawyer, Josh Rice. He's here on Zoom. I don't know why the TVs aren't working, but he's here with you now, so you know that you're not alone. Do you see that motion to sub is in file in Mr. White's case? You have it? Okay, great. All right. So, are you ready?
Sir.
Go for it.
Judge, on July 21st, officers were dispatched to a family assault call in Harris County, Texas. Officers met with the complainant, who is the defendant's stepfather. The complainant stated that after telling the defendant to turn off the defendant's mother's vehicle and come back inside the home, the defendant kicked open the front door and punched him with a closed fist to the left side of his head. The complainant stated that the defendant then fled the scene in his vehicle. The complainant stated that the defendant has been staying in his residence for the past 2 weeks due to not having anywhere to stay. The complainant stated he felt pain when assaulted and wanted to pursue criminal charges against the defendant. The complainant had visible minor injuries near his left ear.
Mr. White, I'm going to find that there's probable cause to go forward with your case. I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Mark Maple as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes, sir.
Now, I'm also, as a condition of your bond, order you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or dope, likewise, your bond will be revoked. You will go into custody. As it stands now, you are on bond for at least 4 to 5 other cases. One of those being an evading arrest here, which is 1,200 days old. I am now revoking that bond and taking you into custody. He goes with you. Josh.
Yes, Your Honor.
It looks like the felony cases are set for September 4th. Are you hired on those as well?
Yes, Judge.
Okay. We need to talk about a bond on the assault case because nothing is set at this point now. Pavel, what do you think on Mr. White?
Your Honor, I would argue, at least with regards to, he's got 3 felony cases on bond for and 1 prior misdemeanor that is from 2021, judge, to which he hasn't shown up since August of 2021. And now he picked up a new case, that's the only case he finally got him back. I would ask for a $5,000 bond on the assault of a family member. Surety.
Judge, just some context. He went to TDC during the time between when he was arrested on this old evading, and he's already been released from TDC. And then we, he had some outstanding charges in Fort Bend that we had to, wrestle with, and
He
then
has
we got
other
him
stuff in
transferred.
Fort Bend too?
He does, Your Honor, but
Holy moly.
but we're fighting and dealing with those. Many of them are old before. The majority of the charges are before he went to TDC.
Josh,
So
God bless you, man. We love you. What else does he have?
I believe he's got a burglary of a habitation charge and maybe a possession in Fort Bend. I'm not sure all of them.
Maybe a possession.
And I believe all of except this new one and 1 Harris County charge, all of them precede his trip to TDC. So we believe that most of them, if he is going to plead them, will be a time served. Some of them, he has alibis, and it was someone making a false accusation against him in order to get a deal on their case or something like that. So,
from what I see, Judge, in Fort Bend, it was deadly conduct, discharging a firearm, theft of a firearm, and theft of property, 2,500 to 30K.
All those 3 are open now?
No, they were disposed of May 17th of this year. So 2 months ago.
But Josh is saying he has open stuff.
Let me see if there's anything else that I see on Fort Bend.
Or anywhere.
I believe.
Look anywhere. Like expand your horizon, man.
It's 31 pages.
Oh.
Mandel controlled substance in Victoria. Tampering, fabricating physical evidence with intent to impair in Victoria.
I guess take your time then. If it's 31 pages, there's no rush.
I know. I'm just trying to go through the felonies. Evading with a prior in El Campo PD. That was 2023. It doesn't show a disposition, so I think that one's open. Let's see. El Campo PD, tampering, fabrication, physical evidence with intent to impair. Felony 3rd degree. Doesn't show a disposition yet.
I guess let me get a PSR and then I'll check it out. Do you mind? What's that?
1 hour later.
All right, guys, don't ask you. Keep it down, please. Okay. We are back with you, Mr. Mark Phillip White. Josh, the floor is yours.
Yes, Judge. I believe that the new family violence case is the result of a physical altercation between his mother and his stepdad that he intervened in. And his stepdad has since agreed to sign a affidavit of non-prosecution. And, just for some context on Mr. White's cases, is I know when you look at it on paper, he's got a lot of past cases, but the majority of them, I believe, are before he went to TDC, and he will either have time served on those, or there's ones where he is falsely accused, so that is why he did not wrap them up before he went to TDC, because he wanted to come back and fight them, such as, I believe, the burglary of habitation in Fort Bend. And so since he's been on my bond and he's been out, he showed up yesterday to the felony court, no problem. He's been working 2 jobs, trying to take care of his family. I believe he has a child. He's expecting a child, and he's, really bending over backwards as far as I can see since he's been out to both keep me paid and take care of his family and keep his jobs. And so because of that, that's why we asked for, a low bond that he can afford, something around the, $10,000 range.
Say,
Judge, we're on the assault family member, we're available to 10,000. With regards to the evading, we'll defer to the court since that's being revoked.
so for the record, we have how many open cases? 8 open cases?
I counted 10, Judge, and I can.
10 open cases. 10 open cases. Where you go, trouble follows. And understand, if you have a child, the apple doesn't fall far from the tree. Let me ask you, if you had a child, would you want it to be like you? Okay, then don't. The last thing we need is more trouble in Harris County, because I don't want, watch the news. All we have is death upon destruction, upon theft, upon murder, one after the other. And here you go with 10 cases. Shed as many tears as you want, but to me, actions speak louder than words. And it just,
Be a better man for my daughter, Your Honor.
don't. You got to take care of yourself first before you can take care of other people. You can't even take care of yourself. How are you going to take care of someone else? I'm setting your bonds at $30,000 each. I'm ordering you, if you get out, to have a curfew of, I don't even want you out with the slightest bit of night. At 7 p.m. to 7 a.m. You must have a curfew. And I'm going to put a GPS monitor on you. And I'm going to tell you now, if I find that you violate these conditions, because from what I understand, your family has a whole host of money. So it's not going to be a problem to get you out. It's probably just a matter of hours. But I'm going to tell you now, you violate these conditions again, I'm going to triple, if not quadruple, all these bonds. Do you understand?
Yes, sir.
No weapons. And what I'm going to have you do is I'm going to have you sign an affidavit with me. Promise me you're not going to have a weapon and that you're not to use drugs or alcohol. And if I find that you do, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you have a weapon or you consume. I will bring you here 2 times a week to prove to me that you're not consuming alcohol or any kind of dope. And if I find that you do, likewise, you will go to jail and I will triple, if not quadruple your bonds, if not quintuple. Do you understand?
Sure.
With 10 open cases, I'm going to have you come here so much, you're going to think it's a career.
Sure.
It's over. The days of you picking up 10 open cases, I'm done with it. All I want is my county to be safe. And I'm going to do everything in my power to protect Houston. Mr. White, this is an affidavit. No weapons, no dope, no alcohol, no contact with the complaining witness. You violate this, I will have a hearing, and you're looking at 6 months every single time. And I'm well within my right to stack 6 months. Do you understand?
Yes, sir.
Please don't send him down. He needs to meet with Tracy. Hey, are you ready? So I can give you conditions on White?
Yeah.
Do you have it? Okay, so you said GPS prior to release, 7 p.m., 7 a.m. No dope, no alcohol. He will come here every Monday and Thursday to test. No weapons, no contact, yes.
No contact with.
Well, no, I mean, I guess don't do randoms because he's going to be coming here. And I guess we'll start it for now, GPS upon release with that. And then once he gets out, that's when we'll start doing the drug testing and stuff. All right. Josh.
Contact with the.
Yes, sir.
Josh, I'm going to keep him so close to me that he's not going to be able to do anything. That's what's going to happen. You know, I'm
I
not
understand,
like
sir.
my child. That's what I'm going to do.
I understand.
I just got a 5th kid.
Judge, can you bail order for this?
Yeah, I'm.
Well, and if I'm able to get that, if I'm able to get that statement from his stepdad, do you think we can lift that no contact just because I think that's his only place to live right now?
Let's talk later. I want the state to reach out to them before I agree to anything. I want the state to reach out to them to get his statement, to see what he says. You know, I want to know if he feels protected, and I just don't know.
I understand.
I'm not going to say no, but I want them to do the rip first.
I
So-
appreciate that, Judge.
He will pop back up on tomorrow's docket.
Okay.
Mr. Hatton.
I will
Hey,
be there. I got to be in Angleton first, but I'll be there right after.
so take your time. I mean, we'll be here and then we got the Zoom, just as you know. So just take your time.
Oh,
and we'll
yes.
be here for
That's
you. Yeah. You got subbed out of White just now. Okay. I don't know if you had anything else.
That's all I had. Thank you.
I do need to talk to you, actually. You guys been doing good. So I want to ease up on some of the conditions. So next time he comes here, let's talk. If you can come here and then I'll ease up, and I want to congratulate him on doing well.
Thank you, Judge.
Yeah.
I will let them know and I will.
So
I'll be
just
here on
next
the second
time,
check-in.
yeah, next time he has court where he comes in,
I think it's next Monday.
let's powwow. and we'll
We'll
talk.
do it.
Yeah.
Thank you,
Okay,
Judge.
for sure, thanks. He's gonna pop up on tomorrow's docket, Josh, so I guess unless he bombs out, just keep us in the know, and I guess we'll see you soon,
Certainly, Judge. I appreciate your time.
for sure. Thanks, buddy.
Thanks a lot. Have a good day. Bye-bye.
You too. Ray,
Mr. Jackson, you are out here because Ms. Rios tells me you are ready to enter a plea in your case. Is that correct?
Yes, sir.
Okay. In just a moment, Ms. Charles, who's seated to my left and is the prosecutor on your case, is going to swear you in. Once you're under oath, she'll ask you a bunch of questions. I'll ask a few as well. The questions are just designed to make sure we're making a record that you understand your rights as a criminal defendant. If at any time during our conversation you are confused by what someone's saying or it's not going the way you expected, will you let me know?
Yes, sir.
Okay, and we'll work on answering your questions that way. Ms. Charles, when you're ready.
Thank you. Mr. Jackson, please raise your right hand. Do you swear or affirm a testimony you will give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Give me all your answer. Please state your true, correct, and legal name.
Daniel Jackson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication you normally take you have not been given today?
No, ma'am.
How old are you, sir?
33.
What is the highest level of education you have completed?
I have my GED.
And are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that in indictment 25 SC 0000706, you were charged with the following offenses: counts 1, aggravated assault; counts 2, battery against a female who is pregnant, misdemeanor; and counts 3, battery, family violence, also misdemeanor.
Yes, ma'am.
Do you understand you have the right to plead either guilty or not guilty to the charges?
Yes, ma'am.
Do you understand if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you about the charges in the indictment, including any potential defenses?
Yes.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes, ma'am, I am.
Has your attorney advised you of the minimum and maximum sentence for every charge for which you're pleading guilty today?
Yes.
And for the record, as to count 1, aggravated assault, the minimum sentence would be 1 year and the maximum would be 20 years. As to counts 2, battery against a female who is pregnant, misdemeanor, the minimum would be 1 day and the maximum would be 12 months. And as to counts 3, family violence, battery, the minimum would also be 1 day and the maximum 12 months. Do you understand?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means the state and the defense will make a joint recommendation to the court, but the court does not have to accept this recommendation. The court can sentence you to the maximum on every charge in its discretion and run the sentences consecutively, which means one after the other.
Yes.
And your Honor, the recommendation is as follows. As to counts 1, we ask that you sentence him to 5 years to serve 6 months, committed to time to serve with the balance on probation. They will, as to counts 2 and 3, 12 months probation to run, 12 months to serve 6, balance on probation to run concurrently with counts 1 and the following special conditions. That while on probation, he will complete the Family Violence Intervention Program. He'll also successfully enroll and complete the Family First Program. He will have no further violent contact with the named victim in this case, Cam Yotta Galmore, who he's currently married to, KAMYOTTAGALMORE. He will submit to probation substance abuse evaluation, follow all recommended treatment, and he will seek and maintain lawful employment. Sir, do you understand this guilty plea may be permanently recorded in your criminal history?
Yes.
Do you understand that this plea may also be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal court? Do you understand then that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes, ma'am.
Do you understand you're not allowed to possess or use a firearm while on probation?
Yes.
Sir, are you a United States citizen?
I hear you.
Are you a United States citizen?
Yes, ma'am, I am.
Do you understand there may be adverse or unfavorable consequences as a result of your plea of guilty today, just as it would have been upon conviction after a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand then by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes, ma'am.
Do you understand also by pleading guilty, you're also waiving the following rights? By pleading guilty, you're giving up the right to trial by jury. You're giving up the right to remain silent and not incriminate yourself. You're giving up the right to confront witnesses against you. You're giving up the right to the assistance of counsel hired by you or to court-appointed counsel. You're giving up the right to the presumption of innocence. You're giving up the right to testify on your own behalf and present other evidence. You're giving up the right to subpoena witnesses and compel the production of evidence. You're giving up the right to have the charges against you proven beyond a reasonable doubt. And you're giving up the right to appeal if convicted of the charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Correct.
How then do you plead to charge 1, aggravated assault in indictment 25 SC 0000706?
No, guilty.
And how do you plead to count 2, battery against a female who is pregnant, misdemeanor in the same indictment?
Guilty.
And how do you plead to count 3, battery, family violence, misdemeanor in the same indictment?
Guilty.
And is your guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand you may only have a limited right to appeal this plea of guilty?
Yes.
Do you understand you have 30 days from today to file a direct appeal of your plea of guilty?
Yes, ma'am.
And you have 4 years from today for the felony charge and 12 months from today for the misdemeanor charges to file a habeas corpus petition challenging the constitutionality of your plea of guilty.
Yes, ma'am.
Your Honor, the state is aware as far as a criminal history of one prior conviction for Mr. Jackson out of Michigan for an armed robbery in 2010. And had this case proceeded to trial, the state would have expected to show that on December 22nd, 2024, officers responded to the Cortland at Buckhead Village Apartments, Cortland is spelled Cortland, located at 3707 Roswell Road, Atlanta, Georgia, 30342 here in Fulton County in reference to a domestic dispute. On arrival, they met with the named victim, Camiota Galmore, who was then married to the defendant, and she explained that herself and her husband had started a verbal dispute which became physical. It started ultimately when Miss Galmore first accused Mr. Jackson of cheating. That escalated into a situation where he accused her of being promiscuous and flirtatious on her social media. Eventually, she tried to walk away from the back room and he followed. And during the course of the second confrontation, where she explained that he smacked her across the face, officers were able to notice a laceration and a mark near her lip area and the face of Ms. Galmore. Ms. Galmore explained that at that time herself and Mr. Jackson had been married for approximately 6 months, had just moved from Indiana to Georgia in October of 2024. And she said at the time the relationship was troubled. And since we're having difficulty sort of getting things going in Indiana and also in Georgia. At the time, Ms. Galmore found out that she was pregnant, and she is, I believe, stated she would be with us on Zoom. She didn't want to give a statement today, and she's due to give birth imminently. And she explained that during the physical assault, he had dragged her out of the back room. Officers did observe some drag marks to Ms. Galmore. She was checked out, and she had no lingering injury to herself or her child. In speaking to Ms. Galmore, she's explained to the state that although their relationship was troubled, she and Mr. Jackson have sort of attempted to co-parent. She said at this point, she's going through some hard times. He is the sole source of support that she has here in Georgia. He does help her financially to pay the rent when they were together. She understands that he did need to take accountability for his actions, although she doesn't wish to have him go down and be incarcerated for any more time than what he's done so far. Understanding her current position, she's 33 weeks and 2 days pregnant. She does want him to be present at the birth. We believe that the resolution we've crafted takes into account the totality of the circumstances, and we ask that you accept it as presented.
There is, I think, Ms. Gilmore, it's listed as Ms. Jackson on the Zoom call. I think she's on, but you said, Ms. Charles, that Ms. Jackson wants to be present, which she is, but doesn't want to be heard at this point.
She did say if you already have questions for her, she'd be happy to answer any questions, but she did not want to give an impact statement at this time.
Got it. Okay, thank you. Ms. Jackson, I do have 2 questions for you, if you don't mind unmuting.
Yes, Your Honor, I'm here.
Thank you. 1, congratulations on the pending arrival of a new child. What is your best understanding as to the due date?
Well, last week I was told that my date was July 5th, 2025, but because I am a high risk, the doctors did change in my fetal monitoring notes that I'm due in about 4 weeks.
Okay.
So
And then,
as of now, it will be like 2 weeks from now.
okay. Excuse me. Other question was, I'm trying to figure out the right conditions to put on Mr. Jackson's sentence. So it sounds like you do not want a no contact provision. You want to be able to have contact with him. Were you thinking that the two of you would live in the same household, or just that he could be present in your household so he can help take care of the child?
I would say both. My husband isn't a threat to me. I don't feel like I'm in danger of my life. It was just that one incident. And when he was released in February, we still chose not to live together, but he was still supporting me emotionally, financially, and mentally, because this is my first child. So it hasn't been any problems.
Okay. Now I'm going to have to ask you another question because of that answer. Mr. Jackson has an open case in state court that includes allegations of battery against a female who is pregnant. I'm assuming that's you, and family violence battery. And the date of the offense is about a month and a half before this one. So the case we're talking about right now was something that happened on December 22 of last year. Mr. Jackson's state court case that is alive and well in front of a different judge. Something supposedly happened between, I'm assuming it's you and Mr. Jackson, given, I can't open the charging document, but given what the charges are, I'm assuming it's you. That was about a month before. And so you just told me, hey, we haven't ever had any troubles other than this. Was there actually another dispute that you all had in early November?
It was verbal.
Verbal, okay.
Yeah, it was a verbal dispute.
Okay. All right. But bottom line, you are not worried about having Mr. Jackson physically present in your life. That's something with which you're comfortable.
Yes, sir. Yes, Your Honor.
Okay. Thank you.
Thank you.
You're welcome. Good luck in a few weeks.
Thank you.
So we have York from pretrial. Can I get any criminal history information you have for Mr. Jackson, please?
Yes, sir. Good morning.
Good morning.
One other thing, other than what the district attorney mentioned, she mentioned the armed robbery. I had a second offense. It was out of Michigan as well. It was a weapons firearm possession by a felon. It was enhanced to felony, habitual offender, second offense notice. And that was a conviction.
And when was that?
I'm sorry, that was April 2017.
Okay. So 2 felony convictions out of Michigan, no other arrests? And how many arrests in Georgia?
Showing 3 in Georgia, but no felony convictions.
Got it. Okay. Thank you, Mr. York.
Yes, sir.
Ms. Rios.
Yes, Your Honor. Mr. Jackson is 32 years old. He has one son, 7 years old, and as you heard, he has a baby on the way. He would be able to go work back at DSL Logistics. He wasn't working as a forklift operator before being in custody. He wants to go back and work there so he can continue to provide for his 7-year-old child and the mother of a child and his new arriving baby. I'm just asking you to accept the plea as negotiated.
Okay. Mr. Jackson, your 7-year-old son is where?
He's in Michigan at the moment.
In Michigan, with his mother?
Yes.
Okay, so you provide financial support.
Yes.
And the DSL logistics job is where?
Ellenwood.
Ellenwood? The address that I have in the system is Savannah.
That's the one I changed when we were trying to find a way for him not to live with the mother of his child.
Got it. That was what you found.
Yeah.
Got it. Okay. I'm remembering now, and I was not super enthusiastic about that. Okay. That's the Savannah connection. So when you get out, your plan would be to stay with Ms. Jackson?
Yes.
Okay. And where is that in relation to Ellenwood?
I believe it's like maybe 30 minutes away. I think that's in East Point.
Okay. How will you get from East Point to Ellenwood?
At this moment, it'll be public transportation.
Okay. How do you know the job at DSL Logistics is still there for you?
I talked to my supervisor previous to getting incarcerated on this case. He told me he told me I was a good worker and all this. He told me when you get out, just reach out to me. We always need work. We opened up 2 more locations, so just let me know what's going on, and
Okay.
we'll create some space for you.
All right. Do you have any questions about what we've been discussing?
No, sir.
All right. And you and Ms. Jackson have been married for how long?
It's coming up on a year next month.
Okay. Ms. Charles, I'm not familiar with the Family First program. Was that a Ms. Rios idea or your idea?
No, it's a new program that is part of the District Attorney's diversion initiative. And what it does is at no cost to the parties, it provides therapy as a family, especially when there's children involved, to help hopefully have them for long-term coping skills, conflict resolution. It's just an addition to the FIP, and it's something that we would want him to do as well as part of his probation, so we can hopefully leave them in a better place.
Okay.
Going forwards.
All right. Well, Mr. Jackson, I find there's a factual basis for your plea. You put your hands on Ms. Jackson in a way that you shouldn't have. And it may be that you were both going at it, but that never justifies it becoming physical. And that's why some of these conditions of probation will hopefully be helpful. I also find that your plea is knowing and voluntary, meaning you've understood what we discussed and that no one has forced you to enter your plea. Do you agree with that?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act, and all that means is that while you're on probation, if you have a minor violation, that'll be something that probation will work through with you. You don't have to come to court. But if it's more serious, in particular, anything involving you putting your hands on Ms. Jackson or anyone else in your family in a way that you shouldn't, that comes back to me. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, sir.
Ms. Charles?
Yes, sir.
Mr. Jackson, is it okay if we electronically sign the indictment for you indicating your guilty plea?
Yes, sir.
You understand that today's plea resolves only the December incident you had with Ms. Jackson. You have an open, active case in state court in front of Judge Edie. That's the name of the judge. You've got a lawyer there, but you're going to need to keep going. Whatever the dates are for that case, you'll need to be showing up. This does not resolve that case.
Yes, yeah, and I talked to my lawyer and she told me, she let me know.
Okay, good. Do you know if the child on the way is a boy or a girl?
It's a girl.
A girl, all right.
I beg for one.
Okay. Mr. Jackson, I was inclined to sentence you to spend a little more time in. I do not want Ms. Jackson to have to navigate birth without you there. So what I'm going to do is sentence you on count 1 to 5 years to serve 3 months with the balance on probation. You've done 101 days, which is more than 3 months, so you'll get released. 5 years to serve 3 months, which means you have 4 years and 9 months of probation on count 1. Counts 2 and 3 are both 3 months to serve. They will run concurrently with count 1. Special condition of probation number 1 is no violent contact with Ms. Jackson. She's referred to as Ms. Gilmore in the indictment, but we're talking about the same person. This is your wife, the mother of your child. No violent contact with her. Number 2, you're going to complete a family violence intervention program. Hopefully Ms. Rios has explained to you, that's not one class for 30 minutes. It's a bunch of classes over time. You don't take them all back to back. You're not going to college. But it's an investment, both financially and in terms of time. You will need to also complete the Family First program. You'll submit to a drug and alcohol abuse evaluation, and that's just you meeting with a counselor to make sure that there's not alcohol or something else behind you getting out of hand with Ms. Jackson. Because if there is, then you're going to get treatment for that, which is good. That's meant to help so that you can be a stable presence in your new child's life. You are not helping your daughter if you're getting locked up every 6 months because you blow your stack and take a swing at Ms. Jackson. That locks you up, takes you away from your family, and your family is disrupted in that way. I'm going to waive your probation supervision fees for the first 6 months. One, because you got to get back to work, and two, you're going to be paying for the family violence intervention program. So we'll throttle back on the supervision fees. I think I covered everything. Any other conditions, Ms. Charles?
No, Your Honor, and just so he's aware that within 48 hours, he'll be contacted by either through Ms. Rios or directly by one of our facilitators of the Family First program.
Okay. So someone will contact you about Families First. You're going to need to go report to probation, and Ms. Simpson's going to give you those reporting instructions in a minute. It sounds like you'll be living in Fulton County. That's where Ms. Jackson is. Okay, so you'll be reporting in Fulton County. I'm going to let Ms. Simpson give you those instructions, but know this, it's going to be.
Oh,
So I have to watch that case version then.
okay. He hasn't bonded out on the misdemeanor case.
Oh,
So,
okay.
once you bond out, then you
Yeah.
report to probation.
Okay, so I want, yeah, so I plan on bonding out as soon as all the paperwork get faxed over, but I just ain't want any confusion going on with me still being in here and.
Got it. If you're locked up, you're not at fault for missing probation, but I'll let Ms. Simpson talk to you about that, and she may say it's 48 hours after your release, or she may say it's 4 days from today. They can decide whether they want to give you a specific time when you show up, or just this notion that, hey, we're going to know when you get out, whether it's today or Monday, and you've got 2 days after your release to show up. Do you know where probation's offices are? Okay, they're a couple blocks from here, but I'm going to let Ms. Simpson handle that. I'm glad you flagged it because you don't want to miss that reporting date, because that just means a warrant, and then here we are all over again. Okay, any questions about anything else?
No, sir.
All right, good luck with your new child, and good luck, Ms. Jackson, with everything. I hope this guy treats you well. So Ms. Simpson's going to come see you. Good morning, Mr. Jones.
Good morning, sir.
Mr. Jones is in court with his lawyer, Ms. Rios. We have Ms. Dilligard here to represent the state. Mr. Jones, I'm not going to list every offense in your indictment. It's a very long indictment, but Ms. Rios tells me that you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
Okay. In just a moment, Ms. Dilligard will put you under oath, ask you a whole bunch of questions. You should not be surprised by any of the questions because I know Ms. Rios has prepared you for this. But if at any point during our conversation you're confused about what's going on, will you let me know?
Yes, sir.
Okay. Ms. Dilligard?
Mr. Jones, can you please raise your right hand to the best of your ability? Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Please state your true, correct legal name for the record.
Edward Ronald Jones III.
Mr. Jones, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
32 years old and 2 years of college.
Okay. And are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offenses? You've been charged with 15 counts of identity fraud, 15 counts of forgery in the second degree, and 15 counts of possession of false identification with a government logo, and a seatbelt violation.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances related to the charges?
Yes.
Do you need any more time to discuss this case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
Yes.
Mr. Jones, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you the minimum and maximum sentence for each charge which you're pleading guilty to today? For identity fraud, the range is 1 year to 10 years. For forgery in the second degree, the range is 1 to 5 years. And for possession of false identification with government logo, the range is 1 to 5 years. And for the seatbelt violation, the range is 1 day to 12 months.
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is to plead guilty to all charges for a sentence of 5 years probation and special condition that he complete 100 hours of community service. Is Is that your understanding of the recommendation? Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that if there are multiple charges to which you're pleading guilty to today, that the court has the right to run those sentences consecutively?
Yes.
And do you understand that if the court orders to order a sentence that differs from the negotiated plea that you were expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
I'm on parole. I just made parole before I got brought over here
Okay.
Parole where?
in Kentucky.
And do you understand that if you're currently on probation or parole, your probation and parole may be revoked based on your entering of a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, to include any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Jones, how do you plead to the charge, the 15 counts of identity fraud, 15 counts of forgery in the second degree, 15 counts of possession of a false identification with government logo, and 1 seatbelt violation in indictment number 24 SC 002627?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a felony charge, you only have 4 years from today to file that petition, and for a misdemeanor charge, you have 12 months from today?
Yes.
Judge, if this case were to proceed to trial, the state contends that the evidence will show that on September 27th of 2022, officers performed a traffic stop on a white Dodge Challenger due to an illegal tint at 2489 Cheshire Bridge Road. While approaching the vehicle and speaking with the driver, they noticed an odor of marijuana coming from the vehicle. They also noticed that the passenger was not wearing his seatbelt properly. They asked both occupants to step out of the vehicle to perform a search due to the odor of marijuana. While searching the vehicle, they opened up the glove box and found 15 ID cards stacked on top of each other. They were all Maryland or Connecticut ID cards. All the pictures of the IDs was that of Mr. Jones. However, they all had different identifying information, names, date of births.
Who was driving? Well, I mean, I don't really, if it wasn't Mr. Jones, was Mr. Jones driving or someone else was driving?
Someone else was driving.
So Mr. Jones was in the front seat, directly in front of the glove box, not wearing his seatbelt properly.
Correct.
Okay.
I'm not aware of any criminal history out of Georgia, but I did see at least 3 drug convictions out of Kentucky. One was in 2016, and I see 2 in 2024.
You said out of what state?
I think it's Kentucky.
Kentucky?
Yes.
Okay. Got it. Okay. Thank you. Mr. York, what do you have in terms of criminal history and Mr. Jones?
So I have 15 cycles with 4 felony convictions. The 3 Madam DA mentioned. Do you want specifics on those?
Just what was I know there was one recently, Mr. Jones, I think was out on bond in a case out of Kentucky when this happened. and then he went into custody in Kentucky and was recently paroled out. He'll clear that up when I get to him. But tell me what the most recent was.
Most recent that I'm showing was a possession of controlled substance, first degree methamphetamine, and that was March of 2024. The arresting agency is KSP Hazard.
Okay.
And I have one additional conviction. It's out of Michigan. This was in 2008. And it was for an armed robbery. I'm sorry, it's unarmed robbery is what it is.
Okay. That's one of the four. So there's 3 Kentucky convictions and 1 from Michigan.
Correct.
Okay. Thank you, sir.
Yes, sir.
All right. Ms. Rios.
Yes, Your Honor. Mr. Jones is 32 years old. He will be living in Georgia if he's released. He wants to drive bulldozers, and he's already looked into the 2-week-long program that he will have to do to learn how to drive that equipment. He has 4 children, ages 13, 5, 2, and 15 months. He's never met the 15-month-old because he's been in prison, I believe, for long as the child has been born. He will be living with his little sister in Atlanta. I just asked you to accept the plea as negotiated. I don't believe anyone's identification was actually ever used from those cards that were in his possession, but he does admit responsibility and would like to get this case resolved and turn a new leaf when he gets released and take care of his children.
Okay.
I did also send you an email from Mr. Campbell, who he worked with.
I read it from I think it's the Boys and Girls Club of Appalachia, the unit director. Okay. Mr. Jones, tell me why you'll be staying in Georgia rather than being in Kentucky or Michigan, or it's hard for me to tell where home is for you.
Yeah, I never lived in Kentucky. I caught the charges down there, and they are transferring my parole to Georgia.
Okay.
Yeah. And
when you say charges, I'm under the impression you have 3 cases there.
Yeah, one was in 2016.
Okay.
And the 2 most recent was in 2020. They indicted me in 2023 on the charges. I was released off a failure to indict when I caught the charges 2 months later.
Okay.
I wasn't on bond or nothing.
Okay. But what's your Kentucky? Were you living in Kentucky for a few years? I mean, there's a gap of time where you just dip into Kentucky, get arrested and convicted.
Yeah, I was down there with a cousin who lives in Hazard, Kentucky.
Okay.
For like a month.
But you have a 2017 case and then some from 2020. So those are 3 years apart.
Yeah, it was 2016.
Okay, 4 years apart. Were you living in Kentucky for 4 years?
No.
Where were you living then?
I was living in Michigan, and then I moved to Georgia in 2022, at the beginning of 2022 with my sister.
Right. So in the in-between time when you were living in Michigan, you would just periodically go to Kentucky and get in trouble? I'm not understanding how, for someone who doesn't live in Kentucky, you have been arrested and indicted multiple times.
Yeah, I was going down there with that cousin who I was mentioning, but yeah, I was doing wrong. I wasn't doing wrong.
I mean, yes, you were doing wrong. I'm just trying to understand how, like, you would take road trips from Michigan, but not with the purpose to go get in trouble in Kentucky. Were you guys bringing drugs down there, or
no? How
would you keep getting in trouble?
Just running with him. We both was doing drugs. I'd have been in rehab down there. Like that director, that was a rehab that I was in down there.
Oh, okay, that's from Kentucky.
Yes.
Okay.
Yeah.
So did you do rehab in Kentucky?
Yes, in this prison incarceration for 9 months.
Okay. And when were you paroled out?
I got paroled April 15th, and then I went to extradition court for here, and you guys picked me up May 10th.
Okay. All right. When did you say your parole date was?
April 15th last month.
So if you didn't have these charges, April 15th, you would have been released from Kentucky.
Yes.
And where would you have gone when you were released?
I would have went to the halfway house that they recommended in Richmond, Kentucky, until my paperwork went through to be transferred to Georgia.
Okay, because your goal was to get back here.
Yes,
And the place you have to stay is with your sister,
yes,
which is where?
in Atlanta, Georgia.
In Atlanta?
Yes.
Okay, and does your sister know you're going to show up on her doorstep in the next few days?
Yes, yes,
Okay.
sir.
All right. And she's willing to let you stay there.
Yes, sir.
Your kids are, any kids here or all kids in Michigan,
All kids in Michigan.
including the 15-month-old?
Yes,
But you've been here since 2022?
yes. They used to come down. His mom used to come down here.
Okay. And do all the children share the same mom?
The two girls, my first two, they have different mom. They got the same mom. Them two boys got the same mom.
Okay. Girls with one mom, boys with another mom. All right. And you provide support as you are able for them?
Yes.
Where in Michigan are your kids?
In Warren, Michigan.
Okay.
And two girls in Warren, Michigan, and two boys are in Detroit, Michigan.
Okay. Anything you want to add?
I just want to say that during this sentence, I changed a lot. I found myself. I know I've been a knucklehead. I grew up rough. I had a lot of childhood traumas, like a lot. But I'm tired of it. I want to get my life right. Like, I want to go back to school and finish out my college courses.
Yeah, you got halfway there.
Yeah, I got 2 years of college credit. I want to get back into a robotic program that I'm supposed to. And I want to take heavy equipment operator so I can drive bulldozers on the landfill that my little brother works at. He drives semi trucks. He's been driving for about 7 years now. But he got stuff lined up for me to help me. I did a complete turnaround. My peer support who wrote you, he's going to help me get my peer support license. I'm gonna help people, with their addiction, with their problem. Like I was a good advocate where I was. Like I was leading my group in a 12-step program, NA and AA.
Good. That's an important way to give back. Our peer support folks in our accountability courts are some of the most important components because you form that connection. Someone's able to say, no, I was where you were. It's one thing for me to say, you need to be a good person, but someone who has struggled in the way that you struggled is much more able to connect with someone who's trying to climb up out of that. And there are plenty of opportunities for you to help down here. Your little brother who drives the semis, he's local also?
He's state to state over the road.
Okay.
But his company is out here and there in Michigan. I think they're in 2 other states as well. But
you understand that if you're on probation in Georgia, you pretty much need to stay in Georgia.
Yeah, I will be working on the landfill.
Okay. All right. And you feel like your addiction is under control right now, or would more treatment be something that I ought to require as opposed to you're going to go to support group meetings because you know you want to?
No, I have over 2 years clean. Yeah, I have over 2 years clean. I feel I have it under control.
How long were you in prison in Kentucky?
For almost 16 months.
So you have 2 years clean, 16 months of which in theory were forced on you as clean time.
Yes, I came through the door on the Suboxone, but when I came through the door, I turned that down. I didn't even want to take that no more. So I got 16 months just clear of Suboxone for the drug.
But you haven't been out confronting all the temptations of life. You feel like your recovery program is internalized enough that
I do, and I'm still being an active recovery. Like I'm still gonna be with my peer support group.
Okay.
Still on FaceTime calls, having group meetings.
How often?
Twice a week.
Okay. All right. I appreciate you sharing all that with me. We don't know each other real well, but it's helpful for me to get that little insight into how you've been working with your struggles. Mr. Jones, I find there's a factual basis for your plea. Pretty simple. You had these 15 IDs, and they sound like they were pretty impressive looking, but they weren't legal. But you didn't have guns and drugs. You had the IDs. I also find that your plea is knowing and voluntary. I am sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, which you will be for a while, if you have a small violation, I'm making this up. Let's say you test positive for marijuana. You don't have to come back and see me. You and probation will work through that. But if it's more serious, you get arrested for anything, that comes back to me and we'll figure out what we're going to do. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Dilligard?
Yes, Judge.
And Mr. Jones, can we sign your name electronically on the indictment indicating your guilty plea?
Yes, sir.
Sounds like you have a place to stay, and Kentucky has already agreed to shift parole down here.
Yes, sir.
All right. Then I'm going to sentence you on all counts except number 46 to 5 years to serve 1 month with the balance probated. You will get credit from April 15th for that month of time because from April 15th onward, the only thing keeping you in custody have been these charges. So you'll be on probation for 4 years and 11 months. Count 46 will be 1 month to serve. It'll run concurrently with all the other counts. You will need to complete 100 hours of community service. You'll need to have knocked out the first 20 in the first 3 months. This isn't something we're going to have just lingering out there. I'm going to require that you complete at least 4 recovery meetings a month. Sounds like you're way ahead of that. You don't need to go someplace probation tells you to go as long as you're able to document the recovery meetings that you are attending. And I will set a behavioral incentive date of May 23, 2028. And all that means is if 3 years from today, you have taken care of your community service, stayed sober, and basically stayed out of trouble, we can end this case early because you will be driving those bulldozers, doing your landfill, taking care of your kids. If things are going well, let's get out of your way. If things aren't going well, you have another year and change of probation. Ms. Dilligard, anything else on behalf of the state?
Nothing further, Judge. Thank you.
Ms. Rios?
No, thank you.
Any questions, Mr. Jones?
No, sir.
Okay, your sister's house is in what county?
14.
Did you say it's East Point, or am I thinking of, where did you say it was? Where is it in Fulton?
It's on Park Lake Drive.
Right, the street doesn't help, but is it Atlanta? Is it?
Yeah, Atlanta.
Okay,
Atlanta.
but you think it's Fulton, Atlanta, and not DeKalb, Atlanta?
Yes, it's Fulton.
Okay, all right. Ms. Simpson, who is with probation, she will not be your probation officer, but she is with probation, is going to give you reporting instructions. You ought to get out tomorrow at the latest. And when you get out, you're going to need to go report to probation so that you'll know who your officer is and what the expectations are going in.
Okay.
Any questions?
No, sir.
Okay, good luck with things.
Thank you.
Hope you meet your newest child sometime soon.
Can't wait.
Good.